Hello everybody. Today we are going to cover legal issues in cloud computing. So this also plays very important role because legally you should be binding to your country laws and then only things can be done properly. So what are the legal issues involved when we are going into cloud? We will see one by one. It consists of different types of concerns like data security, data privacy, then security, intellectual property, compliance, jurisdiction differences and contractual agreements. So these all are legally bound. So whenever some problem arises, based on these rules and regulations, the dispute can be resolved. So these things are also very important. So first we will go with data privacy and security. Cloud providers must comply with various data protection laws. Different countries will have different data protection laws. So whenever you are working with some country, you have to follow the data protection laws of that country. Like suppose if you are in EU, there is some law called GDPR law, it should be followed in Europe, and CCPA law in California. So your data protection laws will be under this country, whatever they are telling, you have to follow that. So users need assurances that the data is handled securely and in compliance with the applicable regulations. Whatever regulations are there, anyhow they are providing the security, but the security measures whatever are taken by the cloud providers, it should be applicable according to the regulations of that country. So data breaches and unauthorized access are significant concerns. So why we are making these laws? If somebody breaks this law, he will be punished. So with that reason, so these are the concerns which should be addressed by the cloud provider. That's why data breaches and unauthorized access laws will help them to punish. If somebody breaks these rules, they get punished. So these are the legal issues with data privacy and security. Next, data location. Data is physically located at different locations and is crucial for legal compliance, especially when different jurisdictions have varying data protection laws. Different jurisdiction means in different countries different rules apply. So once you are in India, you have Indian jurisdiction, and once you go to America, you have American jurisdiction. So it is legal and it is crucial where the data is residing and what laws are applied in that jurisdiction. So it raises questions about which country's law apply and who has access to the data. So every country will have their own laws of keeping data at a particular location, and those laws will tell who can access this data and who can manipulate that data. So that questions are raised and those questions are to be addressed, and it is addressed by cloud providers. Next, data ownership and control. So it specifies, this rule specifies who is the owner of the data and who can control the data, means what, who can access and store the data and who can manipulate data. Those all agreements are done. Cloud service agreements need to specify ownership and control of the data stored in the cloud. So users should understand their rights regarding the data and how it can be accessed, transferred and deleted. So if they break this law, again they get punished. So users should understand properly how those laws, who is the owner of the data, who can access the data and who can transfer and delete the data. Those all ownerships are given under this control. So this should be also taken care of. Next, intellectual property rights. These are very important. So once you make some patent or some technology or some solution, it should not be accessed, it cannot be used by anybody without knowing you. So that is called as intellectual property. Users must ensure that their intellectual property rights are protected when using cloud services. So it means because your data is not available with you and your application is on the cloud, so it should not be possible for everybody to take that application and use wherever they want, because for that reason intellectual rights are given, and this cloud providers should follow those intellectual property rights. So it includes what? Licensing agreements, who is licensed to use this application, copyright infringement, so whether somebody is using it without your knowledge and they are getting benefit out of that, so those things could be taken care, and protection of trade secrets, these all will come under intellectual property rights. This should be taken care by the cloud provider, and so that everybody can put their applications on the cloud or put their important data in the cloud, so they feel secure. So that is why this should be taken care of. Compliance and regulatory requirements. Different organizations and different sectors will have some regulations and compliances rules given by the government or given by the higher authorities. So like if you see, industries such as healthcare and finance have specific regulatory requirements like HIP. These should be followed whenever you are putting your thing on the cloud or your data or application on the cloud. So this regulatory requirements should be followed by the cloud. Cloud users must ensure that their provider meets these compliance standards and that they themselves remain compliant when using cloud services. So because if you are not following that regulations, again you might be fined or you might be punished by the government. So that you should, the people who are putting their application or their data on the cloud, they should be careful in following these regulatory requirements, and as well as you should tell to the cloud providers that these are our regulatory requirements that we need to follow. If we don't, we will fall into trouble. So compliances and regulatory requirements should be done. Next, service level agreements, whatever you have agreed with the cloud, so those also should be followed. So like some like your guarantee, like your including uptime, so means what, in how much time your data will be uploaded, or your data is available where all, how available your data is, how response time is, how data is accessed, whether it is slow or fast. So whenever you are doing the service level agreements, those all things are written. So one has to, cloud service has to follow these service level agreements, and users need to understand these agreements and their implications for liability and compensation in case of service disruptions. So whenever on whatever agreements you have come to, and if these agreements are not satisfied, you should know what compensation you are going to get, or how you are liable if they are not following, if you are not following something, how you are liable, or if they are not following something, some rules which they have come into agreement with, so how they are liable. This users should understand and cloud providers should provide. Vendor lock-in. So users may always face challenges when you migrate your data and applications between different cloud providers due to proprietary formats, APIs and dependencies. So this raises the concerns about dependence on a single provider and the associated risks. So as I said, as we have been seeing in our previous lectures also, different vendors provide with different services. So every provider will not be having the same standards or same frameworks available. So whenever you are moving from one vendor to another vendor, you should be careful to see that your proprietary formats are proper and your APIs and dependencies whatever required are available. If it is not available, then you will be dependent on the single provider only. So you should take care of that also. Next, contractual issues. Cloud service contracts must clearly define the rights and responsibilities of both the parties. How much data they are going to put, what data they are going to put, whether the data they are storing in their cloud, is it legal or illegal, all those, and whether the cloud is providing the service properly or not, all those contracts should, in the contracts they define the rights and responsibilities of both the parties, including service scope, where all you can provide the service, in which regions cloud provider can provide the service, pricing, how much price they are going to charge. These all issues should be talked and decided. Termination clauses, on what basis your service will be terminated, these clauses are also decided, and if any disagreement arise, where the dispute is resolved, whether it is resolved in the country where the data is located, or whether it is resolved in the organization, in the country of the organization who is using that application. So these all contracts must be clearly defined, so that everybody and the users can understand what is going to happen if something goes wrong. Audit and compliance monitoring. Users need mechanisms to audit and monitor cloud services to ensure compliance with contractual agreements, regulatory requirements and security standards. So whenever you are doing some auditing and whenever whether compliance is met or not, in this case these things should be taken care of. So what contractual agreements they have done, whether the regulatory requirements are followed or not, and what security standards whether they have decided on, is this done properly or not. So this should be audited and monitored every now and then. Third party services and subtractors, because sometimes cloud providers may use third party to provide the service. So cloud providers often engage third party services or subcontracts to deliver the services. So users who are going to use that service should be aware of these arrangements and how they impact data security, privacy and compliance. So we have agreement with the cloud provider, but cloud provider is taking the help of some other third party. So what are rules regulations applied to the third party, what and how data is secured, how data security is given, what are the rules and regulations he is following, and what are his compliances and what data privacy is going to maintain, those all details should also be known. Thank you.